Hello, everyone, and welcome to Thursdays Live with Chugh. I'm your host, Sasha Preston-Suni. Thanks for joining us live on LinkedIn, Facebook, and YouTube. So public access files, or PAFs, are an important part of the H-1B visa compliance journey. Every employer of H-1B workers needs to maintain PAFs correctly, or they may face stiff fines and penalties. I'm so excited today to welcome our guest, partner and attorney Min Kim, onto the show. He's going to provide insight into how to maintain PAFs and some common mistakes that employers should avoid. Thanks for joining us, Min.
Thank you for having me.
Wonderful. So before we begin, I'd like to remind you that we are live on LinkedIn, Facebook, and YouTube. This conversation is for informational purposes only, and it does not create an attorney-client relationship. Please send us your questions in the comment section below, or if you're watching the recorded version, feel free to send us an email at info@chugh.com. So let's dive right in. Min, what is the purpose of the public access file, and who does it apply to? Do employers really need to maintain a physical or electronic file?
Yes, I suppose that's the short answer. Employers do need to maintain a public access file because, essentially, what the public access file is intended to capture is that it's part of the requirements for filing an LCA. So LCAs are specific to three categories of non-immigrant visa workers: H-1B specialty occupation workers, H-1B1 for nationals of Singapore and Chile who are being employed in a specialty occupation capacity as well as E3 Australian nationals, working in that same visa capacity. So as part of filing a visa petition for those three categories of foreign nationals, an LCA, a labor condition application, is required. And as part of the LCA, an employer needs to make a number of attestations to the government, specifically the Department of Labor. One such attestation is that they will promise the government that they'll continue to maintain, their public access file. So you also asked, whether the PAF can be maintained, as a physical hard copy or as an electronic file. The answer is that it can be either. I suppose nowadays, with technology being what it is, it's fewer and fewer, hard copy PAFs that are being maintained by, H-1B, H-1B1, and E3 employers. But as long as, the PAF is readily available for public inspection, whether it be, in response to a visit by a Department of Labor government official, or just anyone in the general public, maintaining the public access file physically at the employer place of employment, or digitally, saved electronically as part of their corporate files. That's acceptable.
Okay, wonderful. So it sounds like the PAF is definitely important and required, but what must be included in the PAF to ensure employer compliance?
That's a really good question. Because I suppose it's always helpful to be reminded of the necessary items that should be included in one's PAF, the public access file. So the good thing about the PAF and the instructions pertaining to what needs to be included in that file is that the Department of Labor is rather very specific and very precise. They list a bunch of items that they expect from their end to be included in any kind of public access file. So first, the signed certified LCA needs to be included. There has to be documentation from the employer in determining the wage rate to be paid to the foreign national worker. An actual wage memorandum by the employer needs to be drafted and included as well. And basically, this actual wage memo it explains the system, the matrix that the employer uses in kind of setting their actual wage. Prevailing wage documentation and the source of the prevailing wage also needs to be included. And a copy of the notice of filing that was posted at the intended place of employment, or that was posted electronically on a company's intranet, also should be included as well. And lastly, also the summary of benefits that are offered typically to the U.S. worker population at the company should be included. So either the benefit information directly or reference to that, and just the information pertaining to where someone can find that benefit information if it's included in an employee manual, that should be included.
Thank you for that.
Right, and just really quickly, this would apply, at times, or for most employers, it might not necessarily be so relevant, but in the event of a corporate change, so let's say a company was acquired by a successor company, what have you, there are some very specific requirements in order to document that in updating the public access file. So some things such as a sworn statement by a responsible corporate officer, kind of laying out that the successor entity will accept all the obligations, liabilities, and undertakings of the predecessor entity, would be included. A list of all the affected LCAs, a description of the actual wage system, and the successor entities, FEIN would also need to be included. But as I mentioned, that only takes effect when there is a successor relationship regarding a corporate change.
Great, thank you for that overview. So I know you mentioned that the notice of filing needs to be included in the PAF. Could you explain a little bit further what the requirements are of the notice of filing?
Right. That's a great question. So the notice of filing is fairly critical, and I've noticed that in my practice, a lot of times employers don't, fully understand, end to end the necessity in properly documenting the notice of filing and including that as part of their LCA obligations. So the first thing to keep in mind from an employer standpoint is that the notice of filing it must be posted before the LCA is submitted for processing at the Labor Department. So I suppose essentially you can kind of view it as the LCA submission, and the LCA obviously is a required document in support of any kind of H-1B, H-1B1, E-3 visa petition. The LCA submission to the government is contingent on the notice first being posted. Now, this notice can be posted, electronically, let's say on the company's intranet, if that's available. But if there's no electronic forum to post that notice, then making sure that it's posted at the intended place of employment. So that's a non-negotiable requirement, and I suppose whether it be maybe wishful thinking on the part of employers, not a lot of employers I've noticed take that requirement seriously. But I suppose it kind of opens up a level of liability and risk if employers do not really adopt that across the board. As an alternative to posting the notice, though, even the notice requirement is posted, if an employer so chooses, they can actually post the entire LCA. The LCA copy includes all the relevant information that will be found in a notice of filing. Some of that information, includes that a declaration on the part of the H-1B employer that it's seeking to employ a foreign national in H-1B status, the number of H-1B employees that are sought, a declaration on the position or the occupational classification to which the H-1B employee will be employed in, making it known publicly that the LCA is available for public inspection, as well as providing the contact information at the Department of Labor, where if an interested party, someone from the general public wants to further investigate or maybe issue a complaint, that they have the means to do so by providing the Department of Labor contact information. So that pretty much includes all the content requirements for what needs to be in that notice of filing, or if the employer so chooses, posting the LCA instead of a one-page notice. Another requirement regarding the notice of filing is that it has to be posted in two conspicuous locations at the intended place of employment, and it has to be posted for 10 calendar days. I suppose this is, a point that some employers might confuse because there is a similar, requirement in the green card context. But the notice of filing for LCA purposes for H-1Bs is that it's posted for 10 calendar days, not 10 business days. So that's the bare minimum that it would have to be posted there by the employer. If the employer so chooses to post electronically on their intranet, then obviously posting at 2 locations is not necessary. It just has to be posted electronically in that forum. So here, since we're talking about the notice of filing, I do want to take some time to kind of go into the unique distinctions that are that kind of come into play if an H-1B employer happens to assign one of its H-1B workers to a third-party end client location. So obviously a lot of H-1B employees, they don't necessarily work at the work site of the sponsoring H-1B employer. If it turns out that the petitioning company has a contract with an end client customer, and as part of the contract, they assign workers to work in a specialty occupation capacity at the end client customer site, then there's some unique features that employers should also keep in mind. So I suppose just as background and providing some context to this regarding the unique features involved for third-party end client assignments. The one thing employers I think will be helpful to kind of keep in mind is that what's the entire purpose and objective to to this notice of filing. The entire objective is that the employer has to make a public announcement that it intends to employ an H-1B worker at that general place of employment. So essentially, the workers who are there, whether it be employees at that H-1B employer or employees at that end client customer facility, they have to be reasonably apprised. So one thing to kind of keep in mind is that that employers should keep in mind is that just kind of posting it at their place of employment and just thinking that will be sufficient, that's no longer going to be sufficient here for this posting requirement purpose. I suppose Department of Labor kind of issued clarifying guidance a few years back in 2019 that pretty much stated that if an employer is really serious about making sure that it's compliant to making sure it is compliant for this notice requirement, that it will go one step beyond and provide the means and mechanism for those employees at that end client to retrieve this notice. So whether it be providing the website, the URL for the intranet that it's posted at, or actually posting it at the end client facility. No longer is it going to be sufficient where the employer says it tried to post, it sent the posting to the end client, and the end client just absolutely refused to post that. That's no longer going to be sufficient nowadays.
Thank you for that. That was super informative. And I know a lot of our viewers are actually employers that utilize end client sites. So that information is super impactful and important for everybody. Just a quick reminder for everyone that's viewing with us right now. Thanks for joining us. We are live on LinkedIn, Facebook, and YouTube. Please feel free to submit your questions into the chat box below, and we will answer them live. Also, this conversation is for informational purposes only, and it does not create an attorney-client relationship. My next question is, Min, how long are employers required to maintain the PAF?
Right. So the requirement to maintain the PAF, it's 1 year beyond the date of employment under that particular LCA. And if it turns out, whether maybe the foreign national never joined the petitioning H-1B employer, or perhaps, the foreign national has since moved on to a different employer altogether, but if no foreign national is employed under that LCA, then 1 year from the expiration of the LCA, or 1 year from the withdrawal of the LCA. So that last point is kind of key. And if I can just kind of focus on that, I suppose, if that 1 year retention requirement in retaining the public access file, if it's 1 year beyond the withdrawal of the LCA, that kind of supports the notion, and it will be my professional recommendation as well to H-1B employers that there is an incentive in order to withdraw the LCA. Sometimes employers do a good job and they make it part of their regular policy and practice that if it turns out that let's say one of their H-1B employees has since moved on and they resigned, in addition to making that bona fide termination and letting USCIS know that this employee is no longer employed at the employer, that they go one step beyond and withdraw the LCA. Withdrawing the LCA is not absolutely crucial in order to make it bona fide termination, but if it helps in being able to just retain the supporting public access file for a shorter period, then obviously there's an incentive to do that.
Absolutely. Thank you for that. I know a lot of our viewers might be wondering, the rules in the PAF state that it must be made available for public inspection within 1 day of filing the LCA with the DOL. Is this even possible?
Right. It's kind of a quirky rule. And even though the rule, that's verbatim, that comes from the immigration regulations that speak to this issue regarding public access file maintenance. I suppose it's kind of a rule that's virtually impossible to keep because if a public access file in of itself, it's only considered complete if it has a certified LCA that's signed by the employer in it. Well, the LCA takes 7 to 10 days in order to certify. It's not certified immediately upon submission. So essentially, it's impossible. It's impossible to include or it's impossible to complete the public access file in its entirety without that certified LCA. But employers, this is not really anything that Department of Labor is really targeting. They understand that it's a unique quirk in how the regulations are drafted. So employers shouldn't really concern themselves overly with this issue.
That's a relief. Thank you, Min. I also know that a lot of employers might be wondering, PAFs are very difficult to maintain if you don't have a process and a system in place to help you do it correctly. So what are 2 to 3 of the most common mistakes that you see employers make in terms of LCA and PAF compliance?
Right. That's a really good question. And we can talk about what the rules say, and in theory this is how the system is intended to run. But I suppose the audience today, they're most interested in how this kind of plays out in practice, and some of the the potholes that they should be mindful of as they kind of navigate this issue. So probably the most relevant thing that I keep seeing on a repeated occasion, I kind of referenced it earlier, is the importance of that posting notice. The posting notice needs to be included in the public access file. It has to be there. And it's not good enough where an employer, especially let's say they kind of operate in the consulting industry, and they make their they have their business model where they assign their H-1B employees to end client customer sites. They asked their end client multiple occasions to post this notice, and they've always been turned away. Is it good enough to make a good faith claim that the H-1B employer said, I tried multiple times, my client refused, here's the email proof showing that I attached the notice with clear instructions and they refused to do that. I should be safe. I should be clear in the event of a DOL investigation, right? Well, I think it's a mixed bag. I can't conclusively say that there's not going to be any kind of sanctions or penalties that are assessed to that H-1B employer. The rules are rather clear. Department of Labor has not budged. They want the general U.S. Public workforce to be notified that a foreign national will be employed, that the foreign national will be making a certain salary range and they'll be doing this job. and that advance notice needs to be there. If an employer is really serious about participating in the H-1B program, then they'll make sure that they incorporate this policy and making sure that the notice of filing is publicly displayed, especially if they're employees working at a third-party end client site. So, in addition to that, some other, issues that I've seen in kind of representing employers who employ H-1B, E3, and H-1B1 workers is that it appears there's a somewhat of a misconception that employers can just pay the prevailing wage to their employee, and that's partially correct. Just as background information, how the LCA and how the wage requirements associated with the LCA are kind of put together. Any kind of H-1B and therefore the LCA filing, one of the attestations that an employer makes in terms of the wage that they offer to a foreign national worker is that the employer is promising the government that they'll pay higher, that they'll end up paying the higher of the actual or prevailing wage. And the wage that they end up paying is called the required wage. So the required wage is the wage that's kind of listed on the 129 form and that they're going to be paying that the foreign national employee. A lot of times that required wage is the prevailing wage. If it turns out that, let's say it's a small startup company, they only have a handful of employees, perhaps this incoming foreign national worker is the first H-1B employee that they're going to employ. So there's no history regarding any kind of past employees that they've employed in that specific occupation. So the obligation is that the employer has to pay at least the prevailing wage for that person. But let's say we go to the other side of the spectrum, and we have a long-standing company. They employ many different types of workers. They've went through the LCA process before and the H-1B program before, and they have an incoming H-1B employee that they want to hire, and they say that they're going to be paying that person $100,000 for a software engineer position in the Bay Area. And they say that $100,000 is at least the prevailing wage. Let's say hypothetically speaking that the Bay Area for that geography, software engineers make, according to their prevailing wage system, around $95,000. So why can't that employer just pay $100K to that incoming software engineer that they want to hire in H-1B status? Well, if it turns out that that company hired another H-1B employee a few months ago and offered to pay that employee in the Bay Area $125K, then why is this second H-1B employee being paid $25,000 less? And if it turns out that the company has a collection of U.S. workers who are already software engineers, and those workers are being paid $125K to $145K for doing the same exact job, then it appears that the actual wage, which is defined as what workers in that occupation get normally paid by that sponsoring company in that intended area of employment, that the actual wage is actually in the vicinity of $125K. And if the required wage to be paid this incoming H-1B employee is the higher of the actual wage or the prevailing wage, the fact that the prevailing wage is $100K or 95K, let's say, for the Bay Area, but the actual wage at the company, the petitioning company, is $125K, then this H-1B employee should actually be paid $125K, $125,000. So it's a bit more complicated than let's find out what the prevailing wage is and make sure that we offer our incoming H-1B employee at least that prevailing wage. A lot of times, companies they fail to fully recognize that it has to be the higher of either the actual wage or the prevailing wage.
Great, thank you for those pointers there. So we have a few minutes left here. Please feel free to submit your questions so that Min can answer them live. If you haven't already, just type them into the chat box. I have one more question for Min, and then we'll open it up to questions from the audience. So since there are penalties that are possible if you don't correctly maintain the PAFs, What are the penalties involved? Are there real consequences, or is it just kind of more of a slap on the wrist?
Right. As in most things here, it really does depend. So I mean, it's not lost on immigration attorneys like myself, and people, maybe even like lay people, but also government officials who are tasked with monitoring these things. That public access files are poorly maintained. It's something that Department of Labor officials see on a repeated occasion. So it's not like it's so traumatic and shocking when an investigation happens, an audit happens, and an H-1B employer is asked to release their public access files over the span of so many number of years, and everything is poor. For a first-time violation, knowing that this happens on a frequent basis, Department of Labor likely will just issue that slap in the wrist, as you phrase it. I would be surprised if they really just kind of hit home with any kind of huge monetary sanction or anything of that sort for a first-time violator. They just want to make sure that the employer is aware that this is something that's serious. Up to this point, what a Department of Labor investigation or audit has revealed is that the public access file has been poorly maintained. These are the corrections that the H-1B employer should be mindful of. And moving forward, they should incorporate that, incorporate those modifications and how they maintain their public access files throughout. Now, for repeated offenses, let's say fast forward a few years, another complaint is made against that same employer by a former employee, and Department of Labor, they come knocking on the door and they see that nothing has been changed. Then all bets are off. They issued a warning so many years back. Obviously, that employer did not take it seriously, and they continue to violate the public access file rules in the same manner. Then the second, third, fourth time, Department of Labor might not be so gentle and understanding.
Okay, thank you for that. So we're going to open it up to audience questions. It looks like we have already received a few questions from the audience. Thanks so much, everyone. So our first question is, as an H-1B employer, when do I have to start paying the necessary wage to my H-1B employee? He hasn't reported to work yet. Do I have to start paying him now?
Right. That's a really good question, and it's something that's not talked about often. Essentially, the general obligation that employers should be mindful of is that when does a beneficiary make himself available to work, to enter into that H-1B employment? Because a necessary component of that, or an issue that employers need to kind of keep in mind, is that benching is not acceptable. If an employee presents himself or herself to work, but there is no work available, and therefore that beneficiary is benched on the sideline, waiting for the next client project or next work assignment to be available, then that causes some serious issues. So if the employee presents himself to work, then the wage obligation kind of kicks in. If the employee is not making himself or herself available to work, then there are kind of specific timeframes. We call it the 30-60-day window. If the person is not yet in the U.S., but after the petition approval, they come to the U.S. In that H-1B visa status to start working for that petitioning company, then within 30 days after they come in, the obligation to pay that wage kind of kicks in. The 60-day time frame is that if the person is already in the U.S., after 60 days, the employee 60 days after the employee commences work with the employer, and the petition validity start date has began, then the wage obligation kind of kicks in.
Wonderful. Thanks for that. That was super informative, Min. So unfortunately, we are all out of time today. If you have questions and we didn't get the chance to answer them, please feel free to send us an email. We'll be happy to answer any questions that you have. Our email address is info@chugh.com. Thanks so much for joining us today. To stay up to date, please be sure to subscribe to our YouTube, LinkedIn, and Facebook pages. Join us here back next week for another issue that is very important to you and your business. Until next time, please stay safe and take care. Thank you.